Hi, this is Bobby Halton. We're live at Fire Engineering's FDIC 2009, and I'm here with four of Fire Engineering's most favorite people, four of our most prolific writers, and probably four of the smartest guys that write for us. Unfortunately, I have to sit on this cheek because they're all lawyers, and I don't want to lay it off my wallet because it could just disappear.
We always take a third.
Yeah, take a third. But let me introduce them very quickly. We have Curt Varone, Chip Comstock, John Murphy, and Brad Pinsky. Now, the interesting thing about all four of these gentlemen is not only are they lawyers, they're firefighters. And I'd say they're probably firefighters first and counselors second.
That's what my partners keep saying.
Yeah. But Curt, in particular, has recently gone to the NFPA. So now we have a lawyer who's a former fire chief embedded in the NFPA. So we've really started to integrate ourselves into the organizations and into the activities where we really need to be. And I can't thank you guys enough for stopping in today. Now, you've all been writing fire service court for us for the last 5 years, and now we're going to do fire service court on the radio, on fireengineering.com radio.
Right.
So we're going to have, I know it's tough with you guys to pin you down to weekly or bi-weekly, but that's going to be a place where questions that firefighters have, you guys are going to take seriously and answer and give us good, solid legal advice, and maybe talk about some of the stuff that's happening in the fire service that affects, the whole country in a way, right? I mean, Curt, you were just talking about that, some of the stuff we do, right?
Well, sure. I've always noticed a connection, a close connection between the fire service and law. And there's a lot of reasons for that, but the bottom result in the New Haven case that we were just talking about is a perfect example, that you have a case involving firefighters going to the U.S. Supreme Court, and it's going to set the precedent. One way or the other, it's going to set the precedent for the rest of the country for the foreseeable future on affirmative action and reverse discrimination.
Now, would that affect, we're talking about this, you guys don't mind talking, is it okay to talk about cases?
Yep,
We don't,
sure.
None of you guys are trying it or anything, we can't get in trouble. Would this affect even, I mean, because I'll tell you, I've got an opinion on it, like everyone else. I wrote a piece a month or so ago about it, and what I believe is I think in places where we know there's been discrimination, and clearly there has been in some areas of the country, towards women or minorities or even whites, I mean, it's, depending on where you are, those places, I think the hiring should help to concentrate on the people who are disenfranchised intentionally, not the people who are just, it happened by no one's intent. I think we should target those people for hiring. But I agree that once you're hired, it's a level playing field. Once you get in, because I think that we need to do a little more to recruit women. I think we need to do a little more to recruit in some areas where people have felt it's a, I grew up in New York City. And if your name wasn't John Murphy or Bobby Halton or, forget about it, right? Even Pinsky would have had a hard time. I remember my Uncle George, this is, gosh, I hate to wax poetic here, but my Uncle George one time arguing at the kitchen table, well, people, they eat different food. My dad came down and said, now listen, Georgie, calm down, man. These people are just like us. And whether you're talking about Hispanic folks or African-American folks, you need to let that go. That's the past. And he looks me in the eye and says, Bobby, what are you talking about those guys for? I'm talking about the dang Italians. I don't have to. The Italian guys shouldn't be Brooklyn. I mean, this is the Bronx. This is Irish land, right? I mean, they were, so those boundaries are gone, though, today.
The interesting thing about me with this test, the whole issue deals with this promotional test, and the community was trying to do the right thing. They said, well, we want to follow Title VII and make sure that we have a requisite number of minority candidates. And they didn't know what the test results were, but they knew that no minorities would be promoted as a result of this test. So they just refused to certify the exam. And so the court says it looked like they were trying to follow Title VII. They didn't discriminate against anybody because they threw out the test to everybody without knowing the results, although it would have some disparate impact on white candidates. The real question is, does doing that violate the Equal Protection Clause? And the Court of Appeals, in deciding not to really hear the case in a total, all the judges in the court called en banc, had a 7-6 decision, split decision. And they said, the minority, the 6 judges said, this is a really important issue. We need to address this. And ultimately, they punted and said, no, the Supreme Court's going to have to decide this case. And to me, it is a fascinating decision that's going to have impact not only in fire service, but across all types of minority action anywhere.
This is unbelievable in a lot of ways. I mean, it's something that we all grew up with our entire lives. We all remember the Selma issues and the busing. And
it's just one example of the way that fire and law are connected. I mean, there's arson cases that have sort of set the standard for search and seizure and fair labor standards, Americans with Disabilities cases. The connection between the fire service and law is just, it's always fascinating.
And I'd just like to say up front, I know some of those gentlemen involved, and one of the firefighters involved in this is a Hispanic fellow, and some of the other fellows I've met. And it's not an issue of race to these guys. It's the principle of what they consider to be what's fair and not fair.
What's amazing to me about that case, and if you really look at it, is they came in and they had I think it was 5 hearings about the validity of the test. And folks from I think it was National Fire Academy, one of the federal groups came in and said, hey, this is a pretty good test. And they'd hired a professional testing service to put the test together. And they did a really good job. They had a lot of people from the fire service come in and say, this is a valid test. On the other hand, it appears from reading the opinions that there was also testimony against the test, saying it was invalid. None of the people testified against the test ever looked at the test. They never read it. They never studied it, and that's one of the issues I have.
They could run for Congress.
Yeah, it's one of those cases I read and said, what are they doing here? Why is the court even permitting people to challenge this almost under, are they really qualified experts if they haven't done their homework? And that's the other thing, I don't mind somebody challenging tests, but I think courts and we as lawyers and fire service people need to be diligent and say at the outset on the cases like this, if people are going to come in and testify against the fire service or against things we do or stand for, then they better have the credentials and background and understanding of what we do. And there, as we all know, there are people out there who are willing to, for a fee, come in and testify on a subject, and I think we have to be diligent against those people. And that's one of the issues in this case that's sort of lost.
We're seeing now from decades ago, Boston was a seminal case, Syracuse, New York, where I'm from, is having this issue that years ago, decades ago, they put in standards where the number of minorities had to be in proportion to the minority population of the community. Well, now what we have is we still have those standards in place, but we've well exceeded that proportion, where the number of minorities actually exceeds the fire department proportion. And so now the non-minority population is saying, well, wait a minute, we're being discriminated against, and this happened in Syracuse, became a very big issue. They settled it all, but Boston certainly is still an issue. Everywhere where these proportions were put into place are now we're on the reverse, where, wait a minute, the minority population has exceeded that, so now what is the reverse discrimination? And I think we've seen it, but we're going to see a lot more of that as well, also going towards that line.
And I think with you guys, especially, we've got Curt now in with the NFPA, I think some of the legal stuff that, as a fire chief, I was always concerned about, even as a firefighter. What standards really matter? And, we always talk about the NFPA standards and how important they are, and then one of the things we always need to remember is that we end up in court, they're considered the standard of care almost, I guess in medical terms for firefighters, but you guys have a term for them in court. So you guys will handle those kinds of issues online for us, and you'll talk about that.
And I think we already have on some of them, I think.
Well, I know we've done several columns on them, because you always worry, if you have a fire and somebody gets hurt and you didn't have 1710 staffing, which nobody,
there are no cases on 17 yet. I keep looking for 1710 cases, and there are none yet.
Well, you wrote a great piece on NIMS just recently.
That was actually, that was him.
Brad's.
Yeah.
No, I'm sorry. No, it's one of those, every now and then an article comes out, and I take it, and I put it on my bulletin, and my hand to God and my children, that piece is up on my bulletin board. That NIMS standard, can be used against someone now. And the problem I have with that, and one of the questions I want to ask you guys is, well, what the hell's a toolbox? I mean, I've got a garage at home, and I was potty trained at gunpoint, so I've got I got all my outlines and corkboard, and I know where all my tools and wrenches are. But I'm not an auto mechanic. So my toolbox doesn't have, everything in it. So if I get jammed up on the fire ground and say I just decided the incident commander was enough, and I don't have a logistics section, could a lawyer, no disrespect to you guys, but a bad guy lawyer, could he come in and say, no, you were negligent, pal. You didn't have a branch division, branch Davidian or whatever the heck we're supposed to have.
The big question becomes, what would the reasonably prudent fire officer or fire chief or fire lieutenant,
but who defines that for us?
Well, ultimately, it's going to be the jury. It's going to come down to the jury, and that's one of the beauties, but it may also be one of the shortcomings of our system.
But they're not going to be firefighters.
No, they're not.
But on the same token, you think about the medical profession, there aren't doctors on the jury either. I I mean, that's the thing. The juries are asked to decide complicated issues that relate to, you know, certain professions.
Ergo the old expression, I'd rather be carried by 6 than tried by 12.
Right. I think one of the things that we talked about today in Chip's lecture was you take a look at the reasonable person standard. You know, what are we looking at? And there's no expectation that every fire chief knows every rule or every law. But if you take a look at doing the right thing, the reasonable thing, the correct thing, I think there's always the quarterback, you know, on Monday morning quarterbacks that'll take a look at what you did wrong as opposed to what you did right. And I think one of the things that we see is that maybe lawyers aren't prepared good enough to defend a fire department and its operation, because the lawyer doesn't understand fire department operations either. And so there's been several cases I think that could have gone, you know, towards the fire service and protected the fire service interests that were lost because of representation issues.
Blairsville was a great case. The fire training death where 1403 was used. to
Right, the
prosecute.
assistant chief was convicted. And
Right.
Yeah.
You know, on the other hand, I'm going to take a flip side. If you look at medical malpractice cases, doctors usually win. And the reason for that is because people like the family doctor. People like the fire service. They like firefighters. You've talked about that. I mean, we're the symbol out there of humanity. At least the fire truck is. I think that who is going to be hurt in terms of fire chiefs are those guys who stick their heads in the sand. The guys who just refuse to acknowledge the national standards, who refuse to acknowledge that NIMS even exists, the guys who never look at a NIOSH report and continue to proceed on as they always have, despite clear national standards, those are the guys who are going to get in trouble. And you know what? I don't feel sorry for them. If we have to correct the service, if we have to raise our profession by cutting out some of the bottom feeders and the guys who just refuse to become educated and become more professional, so be it. And I may sound like a plaintiff's lawyer doing that, and I'm not. But I think that's, as I've said before, unfortunately, for some ways or for some change, that's the only way it's going to happen.
The people, you know, the type of person who's at, not to promote FDIC so much, but true, the type of person who's at FDIC, the type of person who's reading what's on fire engineering's website and in the magazine, those are the people who you don't have to worry about. And those people who come to attendance at my conferences or other conferences, they're all worried. And I say, don't worry, because you're here learning. It's the people who don't even want to ask the questions, don't want to look at 1403 before they conduct live fire training. Those are the fire chiefs you have to worry about, or that should be worried.